$200 a share, all cash, sat on the table, and the board of directors said no. That decision forces a precise legal question. When a richer, all-cash bid interrupts a deliberately planned merger, who actually decides the future of the corporation? Time Incorporated built its name publishing magazines and books. The company held a massive footprint in print journalism. But Time also controlled a significant share of the pay television market. They operated the home box office and Cinemax networks, alongside major cable franchises. A 16-member board governed the company, including 12 outside directors. These directors guarded what they call the Time culture, a strict commitment to editorial integrity. Several outside directors, including Arthur Temple and Henry Luce III, feared that expanding further into entertainment would dilute their journalism. Despite those reservations, on March 3, 1989, the board unanimously approved a stock-for-stock merger with Warner Communications. They negotiated an exchange ratio of 0.465. Under this agreement, Warner shareholders would own roughly 62% of the combined company. The board conceived a visionary global strategy. Submitting that merger to a shareholder proxy vote, however, exposed Time to a sudden, hostile cash grab from a rival. The disruption arrived through the public market. Paramount Communications crashed the planned vote. On June 7th, Paramount offered $175 a share for Time. The offer was fully negotiable for all shares and entirely in cash. The conflict immediately shifted to the Delaware Court of Chancery. Paramount and the shareholders sued to stop Time from defending itself. Chancellor Allen ruled first. On July 14th, in a 50-page opinion, he denied the preliminary injunction. He concluded that the plaintiffs were unlikely to win on the merits of their case. The plaintiffs filed an expedited interlocutory appeal. The court granted a 10-day stay of the transaction. To secure a preliminary injunction, the plaintiffs had to demonstrate a reasonable likelihood of ultimate success on the merits. The litigation isolated a single tension. It pitted the statutory autonomy of a corporate board against the immediate financial desires of its own shareholders. The plaintiffs advanced two distinct claims. The shareholders argued that the original Warner merger triggered duties under the Revlon standard. Paramount argued that its June 7th offer triggered duties under the Unocal standard. The Delaware Supreme Court reframed the dispute. The justices asked if Time, simply by entering the Warner merger, had put itself up for sale. The court established two foundational predicates. First, Section 141A of the Delaware General Corporation Law grants the board the explicit duty to manage the business and affairs of the corporation. Second, absent a specific Revlon situation, the board carries no per se duty to maximize short-term shareholder value. The court noted that analyzing corporate strategy strictly through a long-term versus short-term lens is largely irrelevant. Because the law explicitly tasks directors with managing the enterprise, shareholders cannot override a deliberately conceived strategy merely to claim an immediate profit. This chart outlines the two specific circumstances that trigger Revlon duties. A board must auction the company if it initiates an active bidding process to sell itself, or if it abandons its strategy in favor of a transaction that breaks up the corporate entity. The original Time-Warner merger did not meet the first condition. There was no change of control because control already existed in a fluid aggregation of unaffiliated shareholders, meaning it remained in the market. It also failed the second condition. The court found no substantial evidence that the board made the dissolution or breakup of the corporate entity inevitable. The shareholders pointed to structural safety devices in the merger agreement, like a lockup and a no-shop clause. The court ruled that adopting these defensive measures does not trigger Revlon by itself. Time eventually recast the deal from a stock swap to a cash purchase of Warner. The court held that this restructuring did not abandon the strategic plan or make a sale of Time inevitable. Because the board never put Time up for sale and never initiated a breakup, the duty to maximize immediate price never attached. The original merger agreement remained protected. The June 16th restructuring was a defensive reaction to Paramount. Therefore, the court judged it under the Unocal proportionality test. Paramount argued that an all-cash, all-shares offer falling within a range of acceptable values cannot constitute an objective threat. The court explicitly rejected that narrow view. This chart details 3 types of takeover threats. The court accepted the concept of substantive coercion. This is the specific risk that shareholders will mistakenly accept an underpriced offer because they disbelieve or misunderstand management's strategic representations. The Time Board satisfied the first prong of Unocal. They reasonably perceived a threat to corporate policy and effectiveness. They were adequately informed, having conducted a lengthy pre-offer investigation, and 12 of the 16 directors were independent outsiders. The defensive response was also proportionate. The court noted that Time did not attempt a coercive cram-down of a management-sponsored alternative. Instead, the response carried forward a pre-existing transaction in an altered form. Paramount remained free to make an offer for the combined Time-Warner Company. Even though Time assumed massive debt to execute the purchase, that debt load alone did not make the decision unreasonable. The board successfully demonstrated that a fully negotiable cash offer could threaten their corporate policy. That finding provided the legal clearance to restructure and defend their original plan. On July 24th, the court affirmed the chancellor. Plaintiffs failed to establish a reasonable likelihood of success. The March 3rd merger didn't trigger Revlon duties, so it's protected by the business judgment rule. The June 16th defensive restructuring passes the Unocal test. The decision cemented a major doctrinal rule. An all-cash, all-shares tender offer is not threat-free as a matter of law, and inadequate value is not the only legally cognizable threat a board may answer. The court drew strict boundaries around its opinion. This was a ruling on a preliminary injunction, not a final judgment on the merits, and the justices explicitly declined to pass on the underlying wisdom of the Time-Warner merger. The court also issued specific warnings. They cautioned against placing undue emphasis on long-term versus short-term strategy. They also noted that certain confidence letters, designed to dry up bank financing for a hostile bidder, were suspect on their face and only inconsequential on these specific facts. The ruling does not grant future boards unlimited defensive power. Management actions that force a coercive cram-down on shareholders can still be struck down. Proportionality under Unocal remains strictly fact-bound. Delaware's director primacy model, anchored in the business judgment rule, sits apart from the stronger shareholder primacy and co-determination traditions found in parts of Europe. Ultimately, Time did go on to acquire Warner. The final mandate is clear. Absent an active sale or a deliberate breakup of the company, a fully informed board can hold to a deliberately conceived strategic plan in the face of a higher-priced hostile bid. They owe no absolute duty to auction the enterprise.